Hello and welcome to our discussion of religion, exercise, and practice. I'd like to start this week with a very short lecture on a topic that we need to address about how courts have defined religion. And as you might expect, the courts have difficulty at first and then sort of ramp things up as they move along, addressing the free exercise and religious establishment clauses into the 20th century. Our first case comes to us from the 19th century, however, Reynolds versus United States, which was a case about a practice of the Mormon faith called polygamy, which is the custom of having more than one wife or husband at the same time. And this was seen as, by the United States and by the courts, as a threat to public order. The court in Reynolds addresses polygamy in that context, actually, that the United States should have the power to ban the practice of polygamy, regardless of whether it's attached to a religious belief or not, because of the threat it poses to social order. And so the court engages in a historical analysis, but also what amounts to a police powers jurisprudence analysis for the federal government. Of course, we've said police powers is something that applies to the states. It's the power of the states. But here we have an effort by the United States to ban the practice, not just for Mormons, but across the United States for reasons of social order and health and other reasons related to preventing harm and the public good. So the court says that polygamy was not supported at the nation's birth and therefore may be outlawed. Okay, so regardless of the religious belief attached to the act itself, the act can be banned. The court doesn't so much go about defining what is religion as it does addressing what it is not, and in this case, polygamy, the practice of polygamy is not, according to the court, central to religious faith. Also, the court goes on to say that religions not supported by the framers may be regulated. There is a real majoritarian difficulty there presented by this argument that religions that were present at the time of the framing are in some ways superior to others. And the court couches this decision on a really important concept for our further discussion, which is the belief-action dichotomy. The court distinguishes between a belief that one can hold, religious belief, which may not be regulated by the state. The state, the government, national government in this case, may not dictate to individuals what they may believe, but actions are different and may be regulated. And so the court immediately makes a justification for regulation of religion here on this belief-action dichotomy, and thus the free exercise of religion is not absolute. Another case, Davis v. Beeson, you might want to look at in your text. It simply goes on to reinforce Reynolds, ties religious belief in God, ties religion to a belief in God. In other words, any religion that's going to be protected would have to have a belief in a deity. So other religions which may not identify a specific God might not be protected. And also it makes a distinction between religious belief and religious practices, once again, and in reinforcing this belief-action dichotomy, states that if religious practices are considered immoral or pose a threat to public health and safety, then government may regulate them. Okay, in the 20th century, though, we've got a whole different approach, not completely different, but expansive. So, for example, in Ballard, which is 1944, the court says that it's not the test for religious belief is not the credibility of the belief, but the sincerity of the belief held. So one might look at, say, a religion that was started recently called the flying spaghetti monster religion. And this thing is out there on the internet. You can find it, and it was started as sort of initially a tongue-in-cheek view of religion, continues along those lines. But if people have a sincere belief in the existence of a flying spaghetti monster, and that God is central to their explanation of the universe, of the existence of human beings, of religious faith, if those beliefs are sincerely held, then that's acceptable, and should be considered a religion for the purposes of regulation by the state. That's the proper standard. One might actually remember, I think it wasn't Jon Stewart, but it was another individual who has a show on HBO, started his own religion and then went through the process of getting it recognized and getting status from the state, saying that they didn't have to pay taxes. Another one is U.S. versus Seeger, 1965. Beliefs only need to be parallel in a belief in God. So belief in any supreme being is all that is requisite for a religion to be protected under the Free Exercise Clause. But that suggests that certain other types of religions where a god or a particular deity is not central to the belief might not be protected. But it defines religion in terms of a belief in a supreme being. And then Welsh versus United States, the religious belief and its influence on morality and ethics of its members are also a key for determining whether a religion has any validity. There are a number of different interpretations of the Free Exercise Clause. The most literal interpretation is that it says that Congress shall not make any law respecting an establishment of religion or the free exercise thereof. So we're talking about the Free Exercise Clause right now. And the literal interpretation would mean precisely that. Congress cannot make any law that impedes the free exercise. So you can do anything you want to do, and government cannot regulate. But history doesn't bear this out. This interpretation given to the Free Exercise Clause is not the one that was initially given by the framers of it. Jefferson's belief here, Madison's also, was key for understanding that the effort was to prevent the federal government from creating a national religion and demanding religious adherence. This certainly was not the belief of these individuals. It wasn't their understanding, of course, that state governments would be limited in the same way. The court's actions also don't support the literal interpretation. The court has never found religious practice to be absolute. Religious belief, yes, but remember Reynolds versus United States. The first real debate was whether actions can be regulated, and in Reynolds, the court comes down on the side of the regulation. Congress can never regulate opinion or thoughts, but can regulate actions that violate the established social order. So this is sort of key for understanding, a few key concepts for understanding how the court has understood and defined religion. Another important case here is Pierce versus Society of Sisters. Now, this was a case in which a state, the state of Oregon, attempted to outlaw religious teaching of any sort. So certainly not in public schools, but religious schools, private religious schools. The state attempted to ban those, saying that all education must occur in state-sponsored educational environments. The Supreme Court struck down that law. The Society of Sisters, of course, was dedicated to education, providing a Catholic education in a private school setting. And the court said that educating one's children was a fundamental right. It was part of the meaning of due process in the 14th Amendment. And that education extended to transferring or transmitting religious beliefs to one's children. So the state could not outright ban the practice of providing a religious education. Okay, so that's our introduction to religion as a legal concept, and we'll move along.